Good morning, everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today, I'll let you know if I've determined probable cause, and then we will also talk about release conditions. Today is not your trial date, nor is it an adversarial hearing, and so I encourage you to speak with your attorneys before speaking on the record, because everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the Public Defender's Office, I do have an attorney in the courtroom with me, and also there's an attorney from the Public Defender's Office at the main jail. These attorneys are also available to the other persons at the other facilities by phone. For those of you who are represented by private counsel, those attorneys do come to the courtroom. They are able to address your case from here, and they will also, if your private attorney's not here, you can let me know, and I will see how I can get in touch with them for this hearing. Also in the courtroom with me is the attorney from the State Attorney's Office, Mr. Eric Linder, as well as I have representatives from Confinement Status Pretrial Supervision and the Clerk of Courts. And these persons are all here to help to facilitate this morning's process. Some of you, if you're charged with misdemeanor matters or municipal ordinance violations, you may be able to resolve those cases at first appearance, depending on what's going on with you. But felony matters, violation of probation matters, those that the judges, your division judge has already signed a no bond warrant, you are not able to resolve those or make any changes at first appearance. You must see your division judge. All right, after today, for those of you, this is the first appearance, then your case will be assigned to a division judge, and then moving forward, all pre-trial motions, or if you have a trial, will be heard by that judge. All right, Mr. Reedy, is there anyone the jail has asked to call out of turn this morning?
Yes, Your Honor, we have two. On page 6 of the court's docket, we have Mr. Griffith. And on page 14, we have Mr. De Jesus.
Good morning, Judge.
Good morning, Mr. Romero. All right. Griffith, and then who else? Who's the other one, Mr.
On page 14.
Jesus.
De Jesus? All right,
Yes. De Jesus.
thank you. All right, Patrick Griffin?
Griffin.
Griffin. All right, Mr. Griffin, you're before the court this morning on one charge of aggravated assault with a deadly weapon, and I find probable cause.
Does he have anything, Griffin?
Judge, in speaking with Mr. Griffin, my understanding this is his first contact with the criminal justice system. He's a registered voter in our community. He's working at Little Caesars. He's been there for 2 years. He's the store manager. He's 36 years old, been living in our community for his whole entire life. I did advise as far as the no contact with the domestic. He will be abiding by that court order. He'll be living separate and apart. He'll be living with his sister. My understanding, Judge, he's going to be reaching out to both his sister and his father to help post his monetary bond. My understanding, I believe, his father's a truck driver. Considering if the state can confirm, Judge, that this is the first time he's ever been arrested on a domestic situation, I'm going to be asking for the court to consider setting a $2,000 bond.
Your Honor, he has no history. I already spoke about this matter with Mr. Jones. I have no objection to a $2,000 bond, no victim contact.
Okay. All right, then I'll impose a $2,000 bond and no victim contact. Mr. Griffin, that means no phone calls, no text messages, no social media, no third-party contact until further order of the court. Do you understand that, sir?
Yes.
Okay. All right. Jason De Jesus?
Hear me?
All right, you are facing charge one, robbery with a firearm. Number two, aggravated assault with a deadly weapon without intent to kill. Number three, possession of methamphetamine. 4 and 5, aggravated assault with a deadly weapon. 6 and 7, false imprisonment. At this time, I find probable cause for these charges.
Your Honor, the state is going to be seeking a no bond hold on count one upon the finding of proof evident or presumption great. Jason DeJesus was seen by the arresting officer at the location in possession of the firearm. Was seen dropping the firearm and exiting the hotel. The officer made contact with the victims. They advised that DeJesus came inside, locked the door, locked them inside the room, pointed the gun at both of them, and took their belongings, including one of the victims' laptops, which was inside the back office, Your Honor.
The judge would be objecting to the court making a finding of proof evident presumption great at this stage of the proceedings. The state has not called any witnesses. They've introduced no evidence. Apparently, the officer saw Mr. DeJesus, but the state has decided not to call that officer at this hearing this morning, despite the fact that they have the highest possible burden of proof to meet here today, which is proof evident presumption great. So we would be asking the court not to make a finding of proof evident presumption great, and we would be asking the court to set a bond for Mr. DeJesus. If over our objection, the court does find proof evident presumption great, we would encourage the court to exercise its discretion and set bond for Mr. DeJesus.
Right, the court finding probable cause and making a further preliminary finding of proof evident presumption great. And Mr. DeJesus will be held no bond. This is without prejudice for him to have a bond hearing before his division judge. All
And
right?
Your Honor, if I may address the other counts.
Yes.
Excuse me. On the ag assaults, state be requesting a $7,500 bond on 2, 4, and 5, $2,500 bonds on 6 and 7, obviously in order of no victim contact, please.
Judge, I'm going to be requesting a photo order, and also, speaking with Mr. DeJesus, my understanding, he is on disability, doesn't work.
All right, I will sign that phone order. Charge number 2,
Photo order, photo.
photo. Charges number 2, 4, and 5. He'll have a $5,000 bond. And then 6 and 7, $1,500 on each. All right, and again, no victim contact, no weapons or firearms. Okay. Katasia Hubbard,
She's in.
North Broward.
She's in North.
North Broward.
all right. All right, Ms. Hubbard, you are before the court, charge 1, aggravated battery causing bodily harm, domestic. Number 2 is battery causing bodily harm. I find probable cause.
And the state would be requesting a $1,500 bond on count 1, $1,000 bond on count 2, no victim contact. Ms. Hubbard was arrested in 2015 for domestic violence battery against Tori Taylor, one of the listed victims in this case. The charge was dropped. Nothing further, Judge.
Okay?
Judge, I'm going to ask the court to consider pretrial release for Ms. Hubbard. She's been a resident of South Florida for the last 7 years. She is currently unemployed. However, she does have some college background. She went to Broward College. From what I understand, that 2015 domestic violence charge that was dropped by the state is her, I believe it's her only contact. I'm pretty sure that's what she told me. She's also 19 weeks pregnant. And I would ask the court to consider releasing her to pretrial release, because I don't really think that she's going to be able to make any kind of a monetary bond at this point.
All right, I'll ROR to level 2 pretrial, no victim contact. And Ms. Hubbard, that means no phone calls, no text messages, no social media, no third-party contact until further order of the court. Level 2 pretrial means that you'll be on an ankle monitor under supervision, okay?
speaking to? Come on.
All right, Elisa Murphy.
North Broward, Your Honor.
All right, Ms. Murphy, you are before the court on one charge of touch or strike battery, domestic. Number 2 is a felony violation of probation, and that judge signed the warrant with a no bond hold, and so, that's, Judge Fine. So you'll have to see Judge Fine on that violation of probation. I find probable cause.
Your Honor, based on the allegations and that Ms. Murphy is on probation for a violent offense, the state would be requesting a $2,000 bond, no victim contact.
All right,
In light of the no bond hold, that's fine, Judge.
all right, so $2,000 bond as the charge 1, no victim contact, and you'll see Judge Fine for the VOP.
Good luck, Ms. Murphy.
All right. Samantha Steers.
North Broward, Your Honor.
Steers would like to resolve this matter today if possible.
All right, Ms. Steers, you are before the court on a trespassing charge. And I find probable cause.
And, Your Honor, I just received an email. She's being referred to Judge Lerner Wren.
Does she have priors?
One moment. She had a cocaine arrest that was dropped this year and then another trespass at a different location in May.
All right.
I appreciate what Mr. Lender is saying about these referrals that we get about mental health. But it doesn't deal with someone's competency. If she's competent to take a plea, she should be able to take a plea. If she's not competent to take a plea, then she should be referred to Judge Lerner Wren.
I don't know who has had the most time communicating with her, the intake people or you?
Probably the intake people.
Okay.
And I would just also note the determination whether someone sees Judge Lerner Wren or not is not competency versus
I know.
lack of
No,
competency.
I understand that.
Can I plead no contest?
All right. Is there any indication that she's been before Judge Lerner Wren
No, Judge.
before? All right. All right. So, Ms. Steers, if you wish to resolve your case today, then you'll be sentenced to adjudication and time served. Do you wish to accept that?
Yeah.
Okay. All right, before I take the plea, I need to let you understand, because based on my review of the probable cause affidavit, this particular plaza where there's Mango's Supermarket and some other businesses, that you've been trespassed from that area, from that entire plaza. So
Yes, ma'am.
you've got to understand that this morning I'm going to tell you, you cannot return to that area. Do you understand that?
Yes, ma'am.
All right? And so then, if you understand that and you still wish to take the plea, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And do you understand everything we've discussed here this morning?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yeah.
Is there anything about that illness today that would prevent you from making a decision about your case?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
No, ma'am.
Do you understand that?
Yes, ma'am.
Okay. All right. So What plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication time served. I'll give you a year to pay your court costs and no return to that location. Do you understand that?
Yes, ma'am.
All right.
All right, good luck, Samantha.
All right.
Jennifer Pacheco,
North Broward, Your Honor.
all right, Ms. Pacheco, you are before the court on one charge of DUI, alcohol or drugs, and number two is DUI with a breath level greater than .15, and I find a probable cause.
Your Honor, I'm going to ask you to release Ms. Pacheco on her own recognizance. She was raised here in Florida. She lives with her parents. She's had the same job for the last 2 years. She has some college education. She went to Broward College. She has her associate's degree from Broward College, and she has never been arrested before.
Your Honor, based on the specific allegations and her breath readings, she has no record, but I would be requesting a pretrial with random testing.
All right, the probable cause affidavit alleges that there was breath samples of .169 and .172. So based on that, I will ROR to pretrial, and that's going to include random testing. No alcohol or intoxicants. Ms. Pacheco, you need to report to the pretrial office by tomorrow morning. If you don't report, a warrant will be issued for your arrest. Do you understand that? And also, included in your pretrial supervision is that you're gonna be subjected to random testing. So the order is no alcohol or intoxicants. Okay? Yes, ma'am. All right, good luck.
Thank you.
All right, Sarah Richings.
Your Honor, that's North Broward, but that will be a medical reset.
All right, thank you. Medical reset. And Helena Thornton. Ms. Thornton is before the court this morning. Charge one is expose sex organs in public. Number two, possession of drug paraphernalia. Number three, tampering with or fabricating physical evidence. Number four, DUI, alcohol or drugs. And number five, driving while license suspended without knowledge. And I find probable cause.
Judge, in speaking, Ms. Thornton, I see I advise her standard bond, which currently set is $1,500. Unfortunately, she told me she's not in a position to post a monetary bond. Now, my understanding, Judge, she's been living in our community her whole entire life. She's 46. She lives in Pompano Beach with her daughter, and they've been residing there for about 8 months. Her daughter, right now with the expenses, can't afford anything. Ms. Thornton tries to help by babysitting whenever she can, but financially she is indigent. So she's asking to be released on pretrial release supervision, Judge.
Does Ms. Thornton have any priors?
She does, and they're mostly drug-related. There was a burglary and there was a battery, but that was in 2013 and 07. I don't have an objection to pretrial with random testing, Your Honor.
So, Ms. Thornton, I'll ROR you to pretrial supervision. This is going to include random drug and alcohol testing. You need to report to the pretrial office no later than tomorrow morning. If you don't report, a warrant will be issued for your arrest. Do you understand that?
Answer out loud.
Yes.
All right?
Well,
Jack Desrolio.
He's approaching, Judge Jermaine. Come on up, sir.
All right, sir, you're before the court on one charge of touch or strike battery, and then 2 and 3 are violation of felony probation. Those have no bond holds, and you will see, I'm not sure which judge, tomorrow regarding those violation of probation matters. I find probable cause,
Your Honor, State would be requesting a $1,500 bond and no victim contact.
all right?
Judge, considering it has no bond hold, nothing from the defense.
All right, so I'll impose a $1,500 bond, no victim contact until further order of the court, so that means no phone calls, no text messages, no social media, no third-party contact. Malcolm Hurley.
Mr. Hurley? Malcolm? Oh, he's it. Judge.
He's what?
No, it's Robert.
Okay. All right, Mr. Hurley, you are before the court this morning on one charge of domestic battery by strangulation, and I find probable cause. Does Mr. Hurley have any priors?
No.
I'm not showing anything, Your Honor. Based on the level of violence, State would be requesting a $7,500 bond, no victim contact.
Judge, I'd ask you to consider something far less than that. Mr. Hurley has no prior record, as the state has indicated. As the court can see, Mr. Hurley is currently, has a heart monitor on, as he has a problem with his heart. He's been a resident of South Florida for 15 years, has his own home. He's retired, he worked as a printer for over 20 years, and is living on pretty much a fixed income at this point. I can call his wife, and she might be able to come up with some money. But because of his medical condition, he doesn't have a lot of money to post a monetary bond. We did discuss the importance of staying away from the alleged victims in this case, which he has agreed to do. He'd have no reason to have any contact with them. So in light of all of those issues, Judge, we would ask the court to consider pretrial release.
All right, at this time, I am going to impose a $2,500 bond, no victim contact. And sir, that means no phone calls, no text messages, no social media, no third-party contact until further order of the court. Do you understand that, sir?
Yes.
Okay.
Judge, did you pass over Mr. Medicall?
Maybe I did because it was pulled to the side.
Yes, he has, there's some people from the community here on his behalf.
All right, on page 6, Romel Menacol Maris.
Mr. Menkoff, come on up, please. He's approaching, Judge, it's me.
All right, Mr. Maris is before the court on one charge of aggravated battery with a deadly weapon. It's domestic violence. And number 2 is tampering in a second-degree felony proceeding, and I find probable cause. Good morning, folks. All right. Are any of you the alleged victim in this case? All right, is there something you wish to say?
It's my brother, and he's really not been in trouble like this, and this is like the first time that he's ever done this.
All right. Mr. Romero, state, whoever wants to go first.
I'm going to be requesting a $20,000 bond on count 1, a $2,500 bond on count 2. I'm concerned about the level of violence. I'm concerned about threats he made first to the alleged victim, telling her that the next day would be worse than this incident. Also making a threat that essentially to kill her, to quote unquote use his gun and spray up the place. At the time, he did have ownership of a firearm. It was pointed out to law enforcement. They took possession of it. Your Honor, our office has had contact with the alleged victim, and she advised us that she is in fear. The state would also be requesting a GPS monitor, no victim contact, no possession of any firearms, weapons, ammunition. Nothing further.
Say he had priors?
No, just
No priors. Okay.
Judge, in speaking to Mr. Manical, I did advise that today's not his trial day. He is disputing as far as some of the allegations specifically relating to the firearm. Having said that, Judge, as you heard, he has no prior criminal offenses. I believe maybe a traffic ticket earlier this year. Having said that, he's 27 years old. He's been living here since 2001. 7, actually. He's self-employed. He fixes cars for a living. On a good week, if he has clients, he can make about $300 a week. He appreciates his family being here for support. He will be abiding by the court order as far as having no contact with the alleged victim. My understanding is purely going to be relying on his family to help post his bond. I understand his mother is a housekeeper, so their funds are limited. They're not going to be able to afford the $20,000 bond which the state has asked for. I'm going to be requesting that the court consider a $4,000 bond on count 1, a $1,000 bond on count 2, so a total $5,000 bond. And I understand the serious nature of the allegation, so we wouldn't object as far as having Mr. Manical also be supervised by pretrial.
All right, as charge 1, I am going to impose a $7,500 bond. On 2, $2,500 bond. And if Mr. Manical posts his bond, he'll be on level 2 pretrial. No victim contact, no weapons or ammunitions until further order of the court. No victim contact means no phone calls, no text messages, no social media, no third-party contact, okay? All right. Jack Nanda is still on medical loan?
no,
He's
he's
in?
not, but he is. I checked with North. He's in medical reset. He's been at reset all weekend.
All right, so Mr. Nanda is still on medical reset at this time,
Yes, Judge.
okay? All right, Donovan Scradish,
No fraud, Your Honor. He's a refusal this morning.
all right, it looks like, well, the weekend note says it was a medical reset. Do we know if it was actually a reset or it was a refusal?
Well, I'll let them answer.
He did refuse, Your Honor.
Over the weekend
I
as
was
well?
told he refused.
The only issue, Your Honor,
Okay,
normally after 2 refusals, I would ask the court to set bonds. The problem is that there's a domestic violence allegation, so he really needs to be here for the court to issue a no contact order if the court is so inclined. I would ask if the court would be inclined to order the jail through reasonable means to bring him back this afternoon.
Well, I don't know exactly what reasonable means. You know, my feeling generally is if someone refuses, then that puts the jail in a situation of having to basically drag somebody to court, which is not good for the defendant, and it's not good for the deputies, and it's not safe for anyone. I mean, I have no objection to the case being reset till 1 o'clock, but, you know, I don't want to see anybody involved in any kind of physical confrontation because this man refused to come to court.
The alternative is that you let him sit with no bond in jail.
Well, that if he refused, then that's his choice. But you know, if we reset until 1, maybe he'll have had a change of heart, and maybe he'll join us this afternoon.
I'll reset till tomorrow morning. If he wants to sit with no bond, then he'll have no bond.
Okay.
Gregory Roundtree. All right, Mr. Roundtree, you're before the court on an ad charge for resisting officer without violence, and I find probable cause.
Judge, I believe he's
sorry?
also on 18 and 19 of the docket.
Hold on 1 second, Hector.
They miss a couple of the counts. That's why they got them on different pages. This is the whole document.
What other page is he on?
Page 18 and 19.
Yeah, that's funny. All right, Mr. Roundtree, you are before the court today. We'll start with number 1. 1, 2, and 3 are burglary, unoccupied conveyance, unarmed. Number 4 is grand theft auto. 5, 6, 7, 8, 9, 10 through 17 are violation of pretrial warrants, and those are all no bond holds. Number 18 is resisting officer without violence, and I find probable cause for these charges. And these, the violation of pretrial, those are all before Judge Yuson, so you'll have to go before Judge Yuson on that warrant.
On counts 1 through 3, Your Honor, state would be requesting $2,500 each.
Judge, considering all the no bond holds, he's gonna have to go in front of his division judge to seek some sort of relief. Nothing to have from the defense judge.
All right? So 2,500 on 1, 2, and 3, and then the other standard bonds will remain in place. All right, Mr. Shades, you have one. On page 9, Robert Shelton. All right, Mr. Shelton, you're before the court on a municipal ordinance violation for trespassing. I find probable cause. Mr. Shelton, what do you want to do today? Oh,
Can I get out of my on my own recognizance?
well, apparently that may be a problem. Pretrial is, has some information for the court.
Good morning, Your Honor. Nancy Maps of Pretrial Services. He's currently out on pretrial for case number 190109887 MM10A for petty theft, second degree, and also trespass occupied structure. He was placed in pretrial November 2nd of this year.
November 2nd, as in a few days ago?
Yes, Your Honor.
This happened on November 3rd.
Correct.
Did he report? November 2nd was what? Friday? Saturday? When?
Saturday was the second. So
So we didn't even-
celebrating the fact that he got out on pretrial, Judge.
So he didn't even get the chance to he should have been reporting to pretrial this morning.
So Judge, if that was the situation, then he wasn't advised that he wasn't allowed to have an open container, and that would violate his pretrial release conditions.
It says trespass, it's not open
Oh,
container.
I'm sorry. I can't see what to say on this one. So Judge, I think there's a valid argument that he wasn't instructed as to the conditions of his pretrial release. So therefore, I don't know if he could have violated those pretrial release conditions.
All right, but I'm not,
that argument.
Does Mr. Shelton have priors? Please state.
Is everything from Brown? Yeah, he was arrested October 21st. That was on a trespass. He posted a $25 bond.
Well, you know, the police report does say it. October 15th at this same Walmart. October 22nd, November 1st. Then he was placed on pretrial November 2nd. November 3rd, he's,
Mr. Shelton, I'll see you in the division.
yes. I think that would be best. I won't take any action on the pretrial. I'll leave the bond in place. And it's Fort Lauderdale. I don't know if there's a lot, so I don't even know
I'll check to see whether or not
if
he's
community
eligible.
court is an option for him.
I'll check. Eric, did you
All
see
right.
any violent crimes?
All right, now, Mr. Shelton, you'll see your attorney shortly. Lorenzo Brandy. All right, you too.
He's here present, Judge.
All right, Mr. Brandy, you are before the court, one charge of DUI, alcohol or drugs. Number 2, DUI with a breath level greater than .15. Number 3, disobeying or avoiding a traffic device. And number 4, unsecured or obscured tag. 3 and 4 are traffic infractions, not for magistrate. I find probable cause. And he has a total bond of $1,500 for the DUI charges, which I'm inclined to leave in place.
I'm just asking for a phone order, Judge.
All right, I'll sign that phone order. Christopher Connolly.
Please approach, Judge.
Mr. Connolly is before the court on a traffic capias. The charge is driving while license suspended. It looks like he didn't show up for court before Judge Schiff. I find probable cause.
Judge, in speaking with Mr. Connolly, he wishes to resolve this matter today.
All right. So does Mr. Connolly have any other pending driving while license suspended charges at this time?
Does, from what I don't know why he's shaking his head no. From
He does?
what I can tell,
Yeah?
he's got an open case out of Palm Beach County for DWLS and leaving the scene.
All right, Mr. Connolly, I'm gonna leave your bond at $500 at this time.
Judge, in speaking with Mr. Connolly, right now, he's advising me he's never been to Palm Beach, so I believe by that reaction, he does not.
No,
Are you sure you're the right guy?
I'm not.
That's not right.
Do you have, Mr. Connolly's driving record? You know, he has a $500 bond. I'm gonna leave it at that. Oscar Revoredo.
Judge, I've been advised it's a medical reset.
Okay, medical reset on Mr. Revoredo. Jeffrey Dixon.
He's approaching, Judge.
Mr. Dixon is before the court on one charge of exposing sex organs in public. I find probable cause. Yes.
Your Honor, he was placed on pretrial February 28th of this year for case number 180139888 10A for possession.
Okay. So Mr. Dixon is also on pretrial supervision. Pretrial is asking that his pretrial be revoked. Okay,
And he was placed on February 28th of this year.
okay.
Judge,
Just have a medication.
a year and something? Judge, Mr. Dixon advised me that he's been out on pretrial
I
for
have a
about
second case.
1 year? Over a year. If this is his first time picking up a new offense and this is being misdemeanor, if the state can confirm that, ask the court not to take any.
Well, yes, it is a misdemeanor, Your Honor. There is, as the court is aware, there's a lot more going on here, and I don't know that Mr. Romero is aware of the specific allegations in this matter.
Right. All right. And so, do we know how much, do we have any indication as to how much his original bond was on the 2018 case?
It's actually,
Just so Mr., well, without going into details, just so Mr. Romero knows that this incident occurred in Park.
he also has a second case, felony case, for possession of substituted cathinones, that he's out on $1,000 bond on that case.
All right.
The other matter, from what I can tell, based on the charges that ended up being filed, the standard bonds would have been $1,125 on the 3 counts.
All right, so as to case number 18-013-988 CF10A, I am going to grant pretrial's request to revoke pretrial. And charge number 1, I'll have $1,000 bond. Number 2 will have a $100 bond. Number 3 will have a $25 bond. And then as to the new arrest, I am going to increase the bond to $500. Okay?
And Your Honor,
Yes.
the only thing I'd request is an order of no return to Mills
No
Pond
return
Park.
to Mills Pond Park.
Thank you, Judge.
Do you understand that, sir?
Yes,
Okay,
And Judge, would you sign a property order?
sure.
Thank you.
Timothy De Valerio,
Please approach and Judge Jermaine. Sir, what? Defrauding any.
all right, Mr. De Valerio is before the court this morning on one charge of defrauding an innkeeper under $300. It's a second-degree misdemeanor, and I find probable cause.
those aren't the right charges.
And Mr. De Valerio, my understanding, he advised me he has a clean record. Right now, he's homeless, he's looking for work. I'm gonna ask if this state can confirm, I'm gonna ask the court to consider releasing him straight ROR.
I'm very concerned. Maybe Mr. De Valerio meant he has a clean record in Florida, because he's not from here, but he did just plead out October 15th of this year in the state of Pennsylvania, where he's from, to simple assault and was placed on 11 months probation. So I guess he's on probation right now. Also for flight to avoid trial punishment.
So it must be sentencing.
Yeah, I mean, I guess my guess that's Pennsylvania's version of a failure to appear statute.
Okay. All right, and so these allegations are that, I don't know what place of business this is.
Bubba Gumps.
Where, Bubba Gumps?
Yep.
That he went to Bubba Gumps, ordered $41.48 of food and beverages, consumed the items ordered, and then left the restaurant without making any attempts to pay, and he was apprehended a short distance away by the police. All right, so based on these allegations, I am going to increase the bond to $500.
Request
Right.
no,
And
request
no return to Bubba Gumps. Brandon Hunt.
Is here present, Judge?
Mr. Hunt is before the court on one charge of touch or strike battery.
Just arrested, what, like a week ago?
I find probable cause.
Your Honor, Mr. Hunt is currently out on pretrial for case number 190265226 MU-10A for driving under the influence. Placing that his pretrial is revoked.
And Nancy, if you could advise, was a condition of his pretrial no alcohol or intoxicants?
Yes.
And I would also note, Your Honor, that the officer checked off the alcohol influence box in this report.
All right.
Judge, I'm going to be asked, I do realize
Does,
Mr. Hunt out on a DUI offense on pretrial, I believe. My understanding, Judge, is in speaking to Mr. Hunt, he's basically kind of like the breadwinner of his family. He lives in Pompano Beach. He's been working at the same job for 6 months. It's a good job at North Star Seafood Distribution Center. He's been there for 6 months. He's asking the court if the court would consider releasing him on level 2 pretrial.
Wow. I never understand why it would take an ankle monitor for somebody to make a change. You're on pretrial without an ankle monitor. This was a recent, placed on pretrial. And, allegations, no alcohol or intoxicants. There is indication that, alcohol or intoxicants was involved in this new, arrest. That is, touching someone's, body part without their permission is the allegations here. So at this time, case number 19-026526 MU-10A, I am going to grant pretrial's request to revoke pretrial. We'll have a $1,000 bond on that charge. And then as to the new arrest, a touch or strike battery, he has another $1,000 bond and no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Samuel Joseph. Mr. Joseph bonded.
Judge, I've been bonded.
All right, so I find probable cause. And G. Verzan,
Medical loan, Judge?
medical loan. Tyree Brand,
North Broward?
all right,
North Broward.
Mr. Brand, you're before the court on an order from Judge Williams to take you into custody.
What happened again, miss?
There's an order by Judge Williams to take you into custody, so you'll have to go see Judge Williams, okay?
Oh, what that mean?
That means Judge Williams wants to see you.
So, miss, can I ask you this question? Miss? See, I'm in jail right now, you feel me? I want to ask you how many days I'll have to do, you feel me, until I go home.
You'll have to go see Judge Williams, okay?
Just like
All
I
right.
told you, Mr. Brand, you have
When
to go
is
see
it?
Judge Williams.
So, look, when I go home, though, miss? When I get,
I don't know when you go home. You have to go see Judge Williams, okay?
when I go see him.
Richards, I don't know. I don't have the date. Richardson Corville,
These are present, Judge, hear me?
all right, Mr. Corville, you're before the court for an ad charge. This is an immigration hold. It's a hold that's placed by Department of Homeland Security. I find probable cause. It is a no bond hold, so you will have to go before an immigration judge on this charge. Jamal Williams,
He's here present, Mayor.
Mr. Williams is before the court. Charge 1, grand theft auto. Number 2, criminal mischief. Number 3, resisting officer without violence. Number 4, operating without a valid license. And I find probable cause for these charges. All right.
I'm not making any recommendations.
Sure. And Judge, at this time, nothing to add.
All right, so I will leave the bond in place at this time. Michael Uwanowitz,
Come on up, sir.
all right, Mr. Uwanowitz, you're before the court on one charge of possession of cannabis, 20 grams or less. And number 2 is robbery, no firearm or weapon. All right, and I find probable cause, just so that he's aware that this is an incident from May 12 of this year at Dry Cleaning Depot.
Other than
Okay.
2015.
And I find probable cause.
Judge, who is the alleged victim on that, on
Drake.
count 2? I'm sorry.
His mother.
Okay, that's what I wanted to confirm. I spoke to Mr. Iwanovich. He actually told me as far as the date of incident, I was just thrown off by the location. But having said that, Judge, he's 23 years old, been living here for the past 10 years. He's self-employed. He fixes up vehicles. He lives in Deerfield with his mother right now. They've been residing in the same place for 2 years. My understanding is right now, Mr. Owanovich's relationship with his mom is fine. They have no problems. In fact, his mother, from what Mr. Ovanovich told me, has reached out to that police department and made attempts to actually inform that police department that she wanted to drop the charges. Now, my understanding is his mother is the person that's going to be posting his bond. She's retired. Her finances are limited. So we're going to be requesting a $2,500 bond on Mr. Ivanovich's behalf, Judge.
Well, Your Honor, it appears there's been issues with his mother in the past. He was arrested in 2015 for domestic violence against his mother. It was dropped. According to the report, a 911 operator could hear the victim stating, "My son is whipping me." Was asked, "Is he physically hitting her?" He stated, "Yes, my son is physically hitting me." State would be requesting a $5,000 bond, no victim contact.
And in these allegations, it's pretty similar. There is reference to violence toward his mom. Apparently, he asked for, I don't know, he grabbed her blue purse, punched her in the arm. When she resisted, I guess he was asking for money, so he took the purse. He took $20 with a Coach wallet valued $180 that was in the purse. And then he fled. She advised she did not give permission to take her purse, then punched her. Said that Michael punched her with the intent to harm, so she would release the purse. All right, and so based on those allegations this morning, he has a $100 bond on one. As to number 2, I am going to impose a $7,500 bond. and order no victim contact until further order of the court. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
Stephen Robinson.
Judge bonded.
Mr. Robinson bonded, and I find probable cause. Darren Baldeo.
Medical loan.
All right, Mr. Baldeo is on a medical loan. Anthony Sinovich.
Mr. Sinovich, come on up, please. Who's the approaching judge at Maine?
All right, sir, you are before the court. Charge 1, resisting officer without violence. Number 2, leaving the scene of a crash involving damage to property. 3 and 4 are a violation of felony probation. And it looks like you'll see your division judge tomorrow at 9 a.m. I find probable cause. You have a $100 bond on charge number 1. Okay. Christian Royal.
He's approaching judge here at Maine.
He's got some locals.
All right, Mr. Royal, you're before the court on one charge of neglect of child without great bodily harm, and I find probable cause for this charge. I'll hear from the parties at this time.
State is requesting a $5,000 bond, no victim contact. Criminal history includes 2014 burglary of a conveyance, grand theft, VOP 364 days county jail, theft, trespass, loitering 2014, possession of alprazolam, morphine, and theft 2012 VOP, possession of alprazolam, resisting without violence with a VOP 08, burglary of a conveyance 07 with a VOP 364 days. Nothing further, Judge.
And Judge, Mr. Rao would like to address the court. I did advise him not to talk about the facts of the case. He assured me it's not about the facts of the case.
Okay,
I'm just here to ask if you could please release me because my family really needs me to help them pay rent and everything. I haven't seen my family in over a month. I was just there to help them out. Please, I really never neglected my child. I just stepped out of the room for 5 minutes. All right.
Discuss the facts of the case means don't discuss the facts of the case, sir.
All right.
all right.
And
Do we, exactly how old is this child?
He's 3.
All right, so a 3-year-old child on a second floor of a building, and the allegations are more than the 10 minutes that you just stated. It looks like at least half an hour that a 3-year-old child was out in diapers, no shoes, and a shirt. And so, based on these allegations this morning, I find probable cause. I am going to impose a $10,000 bond and no victim contact until further order of the court. Michael Lennon.
Let me see your present, Judge.
Mr. Lennon is before the court this morning on one charge of trespassing. 2, 3, 4, and 5 are felony violation of probation, and those all have no bond holds. And it looks like you'll see Judge Merrigan tomorrow at 8:45 on the violation of probation. I find probable cause. You have a $25 bond on one.
the only thing I'd request, Your Honor, is an order, it appears your neighbors, if you could just order Mr. Lennon to stay off this person's property at,
All right, so Mr. Lennon, you understand you cannot be on this property. Do you understand that?
Yes, ma'am.
Okay. All right, Matthew Parks.
North Broward, Judge.
Hello.
Mr. Parks, you are before the court All right, on this one, I believe that there were 3 attempts and then 1 actual that he entered the vehicle. And I see that we have 2 burglaries, so, and it's probably 2 because 2 of the 2 of the victims declined to
Yeah, I would
cooperate.
imagine so.
So is it 1 attempt and 1 burglary?
That's fine, Judge.
All right, so I make a probable cause finding for 1 attempt, attempted burglary, and number 2 is burglary of an unoccupied conveyance unarmed. And number 3 is a violation of felony probation, and that is for Seminole County. And so Seminole County has a no bond hold on that violation of probation. So I find probable cause. And I'll enter $1,000 bond on each count, 1 and 2. Okay? All right, Sean Danny Ram.
What is that? I don't understand what that means, though. When do I see an attorney then? What?
You have $2,000 bond and you have a no bond hold for Seminole County. All right?
So, how do I get in touch with Seminole County? Who does that? Okay.
Come on up.
All right, thank you.
Resolve your issue with us.
All right, so, Sean Danny Ram, you are before the court. Charge 1 is failure to obey police or fire department. Number 2, battery on a fire officer or firefighter. Number 3, resisting officer without violence. Number 4, violation of felony probation. You have a $5,000 bond on that charge. Number 5 is a traffic KPS. You have a $1,000 bond on that charge. And then number 6 is an out-of-county hold. This is for Palm Beach County, which has a no bond hold and is not for magistrate. As to your VOP, you will see your division judge tomorrow at 9:30 a.m. I find probable cause.
State would be requesting a $1,500 bond on count 2.
Okay. All right, and so I'll impose a $1,500 bond on 2, okay? Nathan Couture.
Mr. Couture, come on up, please. One moment, Judge.
Sure.
Mr. Couture. He's approaching, Judge.
Mr. Couture is before the court on charges 1 and 2, burglar for dwelling structure or conveyance armed. Number 3, burglary on occupied conveyance unarmed. 4 and 5 are felony violation of probation, and those have no bond hold for you to see Judge Cora. You'll see him tomorrow at 8:30 a.m.
Your Honor, the state would be seeking a finding of proof evident presumption grade on counts 1 and 2, a $7,500 bond on count 3, that Mr. Couture be held no bond on counts 1 and 2. Should the court find proof evident of presumption grade, I'd ask the court not exercise discretion. Obviously, he's being held no bond on the probation cases, and I would note on charge 4, he's actually it's on probation for 4 separate counts of dealing in stolen property. He violated probation previously in late April this year. He was actually his probation was extended to 10 years of probation.
In light of the fact that Mr. Couture has no bond holds, Judge, we would be deferring any argument regarding proof evident presumption great until such time as he can appear in front of his division judge.
All right, so at this time, based on the allegations that's before me, I am going to make that preliminary finding of proof evident presumption great as to charges 1 and 2, and Mr. Couture will be held no bond until such time that he sees his division judge for a bond hearing. And as to charge number 3, I will impose a $2,500 bond.
Thank you, Judge. We're gonna be requesting a photo order,
Okay?
Type of order?
a photograph.
Photo?
Roderick Thomas,
Your Honor, it's, that is still medical reset.
yes.
The only thing I would ask is if the court would be inclined to make a probable cause determination.
How many? No, he's here.
Roderick Thomas?
Roderick Thomas.
Oh, I checked and, this morning it wasn't showing.
So
My
Mr.
mistake.
Thomas is before the court on one charge of possession of cocaine, and I find probable cause at this time.
Oh, I'm sorry, there's another Roderick Thomas on the
Oh.
docket that has,
Oh,
one
okay.
extra letter.
Okay. All right, so,
Judge,
yes.
speaking of Mr. Thomas, unfortunately, he advised me that he cannot afford the $1,000 bond. He's homeless. My understanding is he has a mailing address. It says a local homeless shelter in Fort Lauderdale. He gets disability approximately $700 per month. He's been here his whole entire life. He's asking to be released on pretrial release.
Any priors on this Roderick is
Yes,
R-O-D-R-I-C-K?
there are, I'm just checking to see if there's ever been, any previous violations of pretrial or failures to appear. Nancy, I see he was put on pretrial last year. Could you let me know if there were any issues? I know the felony charge was dropped, but I just want to make sure, did he actually report for intake? Showed up for his intake and everything? Okay. I don't have an objection to pretrial, Your Honor, with random testing.
Right, RR to pretrial supervision, and Mr. Thomas, you need to report to the pretrial office tomorrow, sir. If you don't report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
And,
Tomorrow I go to court.
No, tomorrow you go to that address
Oh,
and,
okay.
and sign up, and if you don't go, a warrant will be issued for your arrest.
Yes, ma'am.
And also, as part of your pretrial supervision, you will be subjected to random drug testing. Do you understand that, sir?
How many times drug tests? You'll abide by it, Judge.
If you don't do drugs, you won't have to worry about
I
it.
can make it every week, I can make it, so. All right, so we'll leave it to standard random drug testing.
Thank you, Judge.
Dalmond Miles Pomer.
He's approaching, Judge.
All right, Mr. Pomer is before the court on one charge of robbery, no firearm or weapon, and then charges 2 and 3 are misdemeanor capiouses that were issued September 17th of 2018 because you did not show up for arraignment. Those charges are resisting without violence and trespassing. I find probable cause.
Your Honor, the state would be requesting a $2,500 bond on count 1, order no victim contact, no return to this Dollar Tree.
Judge, we're just gonna be requesting a phone order.
All right. I am going to, based on these allegations, it appears that Mr. Pomer has been to this business several times. The allegation says that he entered the store on this day and is a regular customer. Defendant entered and violated the store policy by taking his backpack with him and proceeded to the rear of the store to get laundry detergent, fabric sheets, and stain remover. He placed the items on the belt of checkout where he was working, and then he was told that they're refusing him service because he violated the store's policy. And so then he says, I will just take the items. And then he passed all points of sale, and then that just escalated into one big rumble, taking the iPhone, struggling with the store personnel. Do we know if the previous trespass is from the same location or the pending trespass?
One moment, Judge. No, it's not, Judge.
Sorry?
It's not.
It's not? All right.
But I can tell you that incident occurred allegedly at a Dunkin' Donuts where he had interaction either with, I don't know if it was an employee or a customer, but he ended up grabbing a chair in the dining area and threatened that he would hit her and told her that he would put her in the hospital.
And Judge, my understanding, and speaking of Mr. Miles, he just got a new job. So right now financially, he's not in a position to post his bond. He does have family living in our community. Specifically, his uncle is going to try and reach out to see if he's willing to help him out post a monetary bond. That's why I request phone order. He's been living in our community for the past 11 years. He's 29 years old. He lives locally here in Hallandale, where he's been living at the same place for 11 years with the rooming. His share of the rent is approximately $600. So financially, he's really not going to be able to afford that much of a high bond.
All right, so Mr. Pomer has two pending charges that he failed to appear. This has like been over a year. Hasn't gone to court. And these allegations involve violence. I am going to impose a $5,000 bond. No victim contact and no return to that Dollar Tree. Reynolds Lavon Black. All right, Mr. Black, you're before the court on a violation of parole, sir, and that is a no bond hold. You will have to appear before Department of Corrections for a parole hearing, okay? Martin Payne.
I'm advised he refused, Judge.
All right, so Mr. Payne also is facing a petty theft charge. Wow, he has 2 pages of AKAs. All right, he has a petty theft charge, and he also has 2 out-of-county felony holds, and those are no bond holds for Dade County. So at this time, I find probable cause in absentia. He has a $100 bond on charge number 1. Amari Molina.
Please approach the judge here, man. Come on up, sir.
Mr. Molina is before the court on 1 petty theft charge, and I find probable cause. It's a felony petty theft, so it's a 3rd-degree felony charge.
The last time, 20 years ago in Miami-Dade County.
Judge, my understanding is Mr. Molina, he said his last time he's had contact or in trouble, as he said, about 20 years ago. So we're asking the court to consider releasing him on pretrial release on this nonviolent offense.
What is this conviction that is alleged of January 11th of 2016?
Oh, that was, I think, an incident in a Miami Beach. I think it was like an argument in Miami Beach, Florida. But I'm a resident of Sunrise, Florida for 6 years. Never had a problem in Sunrise.
That's,
It's Florida.
that's not what you said, sir.
And,
Yeah, I mean,
what do we have?
just looking at the numbers, Your Honor, he's got, let's see. Ten prior felony convictions. According to Florida's summary report, there's a total of 77 cases where dispositions weren't reported. 54 prior felony charges, 23 prior misdemeanor charges.
Seems to know about the 2016 case.
Oh, yeah, no, they.
What were those
Okay,
charges?
one moment.
All right, so it's not been over 20 years, like he says. So I find probable cause and you have a $750 bond. LaTroy Brady. Mr. Brady is before the court on charge 1, possession of cocaine. Number 2, possession of drug paraphernalia. Number 3, violation of felony probation. I find probable cause. Sir, on your violation of probation, you will see Judge Fine tomorrow at 8:45 a.m. I find probable cause and you have a $1,000 bond on charge number 1. Do we have Ronald Genty?
Advised he refused, Your Honor.
What is with refusing today?
Have to do a better job with our invitations. Maybe we should make them like gold-plated or something. I'd ask you to reset him tomorrow, Judge. It looks like he was a medical reset yesterday.
And
That's
only-
what it said on something else.
Right, and only because I don't know if it's truly a medical reset or if it was a refusal.
Right,
So-
none of us were here, so.
And it was twice. All right. Well, it says refusal, so I will reset him for tomorrow,
Thank you,
and
Judge.
then we'll see what happens. All right, do we have Alexander Orengo today?
Still on loan.
Still on loan? Okay. And this is the other Roderick with an E, Roderick Thomas.
He's still on loan, Your Honor. I would ask if the court would be inclined just to make a probable cause determination.
Is it only, oh,
It's been, it was, I think at least a couple days.
Saturday and Sunday.
Great on this?
Well, I'm not gonna, I imagine you'd object to me making that
Well,
request without him being
I'm gonna
present.
Yeah,
do
well,
that.
I would, yeah.
Okay, well, that's why I didn't ask.
Okay.
I think that would be the prudent thing to do. He's not here, so I will I'll find probable cause, and then we can reset him for bond determination.
That's fine.
All right, and then Jean Blanco.
No problem.
All right, Mr. Blanco is before the court. Charge 1 is possession of drug paraphernalia. Number 2 is possession of open container. And number 3 is a violation of felony probation, which has a no bond hold.
I'd ask you to just leave the bonds in place, Judge. on
All
count
right, so you'll have to see Judge Tobin Singer on the violation of probation. I find probable cause, and you have a $100 bond on 1. All right. I believe that brings us to the end of our morning docket. Thank you, everyone, and I'll see you at 1 p.m.